Hi friends, in this video we are going to deal with the case summary of the important and latest Supreme Court judgment pronounced now in the area of criminal procedure, that too in relation to matters involving summoning of witnesses under section 311 of CrPC. To know more about it, please watch the video fully. If you feel that it's useful to you, please like, share and comment, and never ever forget to subscribe to it, and further click on the bell icon next to the subscribe button.
Hi everyone. Today I'll be discussing a latest Supreme Court judgment. So in the important judgment titled Varsha Garg versus State of Madhya Pradesh, which is pronounced on 8th August 2022, the Supreme Court has held that an application under section 311 of CrPC cannot be dismissed merely on the ground that it will lead to filling in the loopholes of the prosecution's case. The facts of the case would be that an advocate was brutally murdered outside his office. So following the homicide, FIR was registered for an offence punishable under section 302 read with section 34 of IPC. An application was filed under section 311 of CrPC seeking to summon the nodal officers of certain cellular entities along with the decoding registers to trace the mobile numbers of accused on the grounds that the document which the prosecution desired to summon does not form a part of the investigation, and the document has not been obtained during the course of the investigation, and the same was rejected by the Sessions Court. So consequently, on the same day, the trial court also recorded that the evidence of the prosecution stood closed. The appellant, the spouse of the deceased, challenged the trial court order before the High Court invoking its jurisdiction under section 482 of CrPC. The High Court upheld the same, and being aggrieved, the present appeal has been filed. The Supreme Court has held that the objection which was raised by the respondents regarding the bar under section 301 of CrPC, on the basis of which it was argued that it is not open to the appellant, who is the spouse of the deceased, to pursue the proceeding, lacks substance. Subsection 1 of section 301 of CrPC, it stipulates that the public prosecutor or the assistant public prosecutor in charge of the case may appear without the written authority before any court in which the case is under inquiry, trial or appeal. Subsection 301 of CrPC postulates that if such case any private person instructs a pleader to prosecute any person in court, the public prosecutor or the assistant public prosecutor in charge of the case shall conduct the prosecution, and the pleader so instructed shall act under the directions of the public prosecutor or the assistant public prosecutor, and may with the permission of the court submit written arguments after the evidence is closed in the case. In the present case, the application for the summoning, if witness and for the production of the decoding register was submitted by the state. Hence, the bar contained in section 301 of CrPC does not stand in the way. The power under section 311 of CrPC can be exercised at any stage of any inquiry, trial or other proceedings under the CrPC. The latter part of section 311 of CrPC states that the court shall summon and examine or recall or re-examine any such person if his evidence appears to the court to be essential to the just decision of the case. Section 311 of CrPC contains a power upon the court to broad terms. The statutory provision must be read purposively to achieve the intent of the statute to aid in the discovery of truth. The power of the court is not constrained by the closure of the evidence. Therefore, it is clear that the broad powers under section 311 of CrPC are to be governed by the requirement of justice. The power must be exercised where the court finds that any evidence is essential for the just decision of the case. The statutory provision goes to emphasize that the court is not a helpless bystander in the derailment of justice. Quite to the contrary, the court has a vital role to discharge in ensuring that the cause of discovering truth as an aid in the realization of justice is manifest. Section 91 of CrPC empower any court to issue summons to a person in whose possession or power a document or thing is believed to be, where it considers that production of the said document or thing is necessary or desirable for the purpose of any investigation, inquiry, trial, or any other proceedings under the CrPC. So in the present case, the application for the prosecution for the production of decoding registers is relatable to the provisions of section 91 of CrPC. So the decoding registers are sought to be produced through the representatives of the cellular companies in whose custody of possession they are found. The decoding registers are a very relevant piece of evidence to establish the correlationship between the location of the accused and the cell phone tower. The reasons which weighed with the High Court and the trial court in dismissing the application are extraneous to the power which is conferred under section 91 of CrPC on the one hand and section 311 of CrPC on the other hand. So the summons to produce a document or other thing under section 91 of CrPC can be issued where the court finds that the production of the document or the thing is necessary or desirable for the purpose of any investigation, trial, or proceeding under CrPC. As discussed earlier, the power of under section 311 of CrPC to summon a witness is conditioned by the requirement that the evidence of the person who is sought to be summoned appears to the court to be essential to the just decision of the court. So, prosecution witness number 33, 41, 43 and 48, who were the nodal officers of Idea, Airtel, Reliance, Vodafone, have already been examined. The relevance of the decoding register clearly emerges from the statement of prosecution witness number 41. Hence, the effort of the prosecution to produce the decoding register, which is a crucial and vital piece of evidence, ought not to have been obstructed. In terms of the provision of section 311 of CrPC, the summoning of the witness for the purpose of producing the decoding register was essential for the just decision of the case. The objection of the respondent was that the application should not be allowed as it will lead to filing of the lacuna of the prosecution's case. However, even the said reason cannot be an absolute bar to allowing an application under section 311 of CrPC. So in the present case, the importance of decoding registers was raised in the examination of prosecution witness number 41. Accordingly, the decoding registers merely being additional documents required to be able to appreciate the existing evidence in the form of call details which are already on record but uses codes to signify the location of the accused, a crucial detail which can be decoded only through the decoding registers. The right of the accused to a fair trial is not prejudiced. The production of the decoding registers fits into the requirement of being relevant material which was not brought on record due to inadvertence. In the present appeal, the argument that the application was filed after the closure of the evidence of the prosecution is manifestly erroneous. As noted already, the closure of the evidence of the prosecution took place after the application for the production of decoding registers and for summoning of the witness under section 311 of CrPC was dismissed. Though the dismissal of the application and the closure of prosecution evidence both took place on 13th of November 2021, the application by the prosecution was filed on 15th of March 2011, nearly 8 months earlier. As a matter of fact, another witness for the prosecution was also released after examination and cross-examination on the same day as recorded in the order dated 13th November 2021 of the trial court. Therefore, the decision of the High Court which is impugned in the appeal is unsustainable. The application filed by the prosecution for the production of the decoding registers and for the summoning of the witnesses of the cellular companies for that purpose is allowed. So I hope you'll find this video helpful.